Could Proptech solve the conveyancing issues of the UK property market? Today, I'm joined by Sally Holdway, who is a conveyancing solicitor. Sally, can Proptech solve the conveyancing problems? Talk to me.
Yes, it can, Chris. I mean, there's a short answer for you, right? Hooray!
Yeah, we do.
Easy.
Yeah, we can start the video now. Yeah, come put some meat on the bed.
Yeah, so look, my background is as a conveyancing solicitor. The work that conveyancing solicitors are doing up and down the country day in, day out is difficult. This isn't a simple vanilla process. It's a complicated legal task that needs to be gone through. We need to make sure that we do the due diligence correctly for every single transaction. But there is a huge amount that technology can be doing to do the heavy lifting for conveyancers. The amount of work that they have to do has increased.
Is that like email? Because I mean, some solicitors won't even email you, will they?
Harsh, I think that one. I don't know any conveyancers that are not emailing anymore these days, Chris. But I take your point on board.
Fax.
All right, maybe we still have a few faxes in the back office. But the challenge we've got as lawyers, right, is we are very heavily regulated.
Okay, so any more regulation than when there was in 2008?
Yes, I would.
What, to triple the time it takes to sell a house?
Well, it's not just down to regulation of the solicitor's profession. It's around to regulation around Building Safety Act, leasehold properties. There's a lot more work that the lawyers are having to do these days.
Okay, probably in London with leasehold, but everywhere else it's mostly freehold.
Well, now I'm going to push back again and say, what about new build estates? There's lots of variations we have to do there, but we are singing from the same hymn sheet here, Chris. Okay. There's a lot more that we can be doing, and as a profession, we could be embracing technology more. Just to explain the reasons why we don't, though, deviating away from any process which is tried and tested is a big risk for lawyers. All lawyers have to carry professional indemnity insurance, and just to put that in context, the annual premiums for that can be in six figures, even for fairly small law firms. Conveyancing, believe it or not, is one of the riskiest areas that lawyers can get involved with, because if it goes wrong, the payouts are substantial. So we need to make sure that we're dotting the I's and crossing the T's, and it's why as a profession we can be perceived, I think, sometimes as change averse. But what I would say is all of that is changing, and certainly a lot of the firms that we're working with and engaging with are really getting on board with the Proptech, LawTech community to be looking at how can we be using technology to be doing the heavy lifting here. So the lawyers can be focusing on the bits they need to do, but we're stripping out a huge amount of the delays. One great example is a concept of preemptive enquiries. So traditionally, inquiries wouldn't come out of the woodwork, certainly until post-offer.
Oh, sorry, I thought you had to wait until week 17 for that one.
We generally do, right? We love week 17. It's always the best one, right, isn't it, to go forth for the inquiries? Yes, indeed. But why is that? It's because we have this linear process, and generally speaking, it doesn't start until the point of offer.
Okay, so why go linear? Why can't you just set your dogs off running in different directions and wait for them to all come back in?
That's exactly what's happening now, and it's how things are starting to change. One of the big catalysts of this that we've seen is material information. If agents are doing material information where they're engaging, particularly with lawyers or with the technology providers that can also aggregate all of the conveyancing documentation, it means, first off, you can have a contract pack which is sitting on the file before a buyer even comes along, without the contract, obviously, because we don't know who the buyer is at that stage, but everything else is there and ready to go, including searches. So that's a real boon. That can save at least a month in a transaction. But what you can then do, because we are now digitising that data as well, is we can have preemptive inquiries. What do we mean by that? Well, there are systems now. We have one in our Homeowners Passport. Once again, others are available, which will read the title deeds automatically and spot if there's any issues which are likely to cause a week 17 inquiry, and ask it of the seller at the point that they're going through answering the questions they need for material information.
Is this AI?
Some of it's AI, doesn't even need to be AI. A lot of it is just if-then statement decisioning in the technology. And what does that mean in practice?
Sorry, statement decisioning technology. What the hell's that?
If-then statements. So it's just it's a bit of a binary decisioning that you can have in technology that doesn't need all of the amazing ChatGPT type AI capability to be OCR reading all the documentation and doing the artificial intelligence. It can just be as simple as receiving a flag to be yes or no. For instance, is the property leasehold, yes or no? If it is, we know we're going to have to raise some inquiries about it. And that means then that not only are the lawyers getting all of the documentation on their desk from the day that they're instructed, but they're also getting answers to inquiries before they've even been raised at week 17, meaning that it never happens in the first place. Certainly, one of the descriptors I've heard of inquiries is it's just a missing piece of data, isn't it? A lawyer has to ask a question about something which relates to the title because it's not on their desk at that stage. So again, it's not particularly glamorous, but hopefully a practical example of how the technology can be helping to speed things up.
Just before we come back to Proptech, is it fair, or is this just urban myth? The solicitors, where you're employing someone on minimum wage to do a tick box exercise, and they're asking the other side for a seaside search when they're in Droitwich or something like that.
That's complete urban myth. That's that never happens, Chris.
Does that not happen?
Look, everyone's got their experience of frustrations in the system, haven't they? And those checklists have got longer. And as we've had changes in the rules and regulations. But what drives that kind of behaviour? Well, again, it can be down to risk tolerance, so far as the law firms are concerned. We need to go through and ask every single question on our list.
But this is the bit: it start at number one and finish it, and they won't go to the next one until they've done that one.
Well, exactly. And I say this is where what we need to be doing is changing the chronology, and changes like the material information rules are already starting to do that. So we're getting on the front foot a lot sooner. But also, let's not wait in this linear way to do one thing when the other job has been completed. Another example is searches, right? Generally speaking, it would be the buyer's solicitor who would commission the searches, the conveyancing searches, which wouldn't be done until they were in funds from their buyer client. These days, there's lots and lots of different products that are out there, and lots of estate agents which are now providing the search packs up front. And then they're clearly available from the moment an offer's accepted as well. So I think there's two things that are happening. We're changing the chronology, we're swapping things around, which is having tangible impacts on reducing those transaction times. And where we can, we're looking to leverage the technology a lot more than we've done so in the past.
Thank you for your time today, Sally.
Thanks for asking me.